Did you know that if you go under contract to sell your house, the contract falls through and you fail to authorize the release of the escrow deposit to the buyer, you could be liable for 3 times the amount of that deposit to the buyer. So we just filed a new lawsuit on behalf of a buyer for an escrow dispute. Under the contract, the buyer had a financing contingency. They were denied financing within that financing contingency period. They terminated the contract properly pursuant to that financing contingency period, and the seller has refused to authorize the release of the deposit to the buyer. The title company holding the deposit will not release it unless both parties sign off on, as it should be. And we see this often in escrow disputes because oftentimes, even as a buyer or seller, if you know you're not entitled to that deposit, if you play hardball, oftentimes you can get half of it or you can come to some sort of split, even though you're not entitled to any of it. But you need to be careful because there is a cause of action here in the state of Florida called civil theft. And civil theft occurs when you come into possession of property of another and you maintain that possession, you refuse to release that possession unlawfully, depriving that party of the ability to use whatever it is, in this case, the escrow monies. Florida courts have held that civil theft does apply to escrow disputes. So in this case, even though the money is not physically in the possession of the seller, by it being an escrow and the only thing that's needed is the seller's authorization or signature for it to be released, because they're refusing to do that, that falls under the civil theft statute, and the seller could be on the hook now for 3 times the amount of that deposit money plus all of buyer's attorney's fees and costs. Why is it 3 times the amount? Because the Florida civil theft statute states that anybody who is liable for civil theft owes treble damages, which means 3 times the amount of the other party's actual damages. So sellers need to be really careful about playing hardball with these escrow deposits. If as a seller you're entitled to it, play hardball all day long. But if you're not, and you know you're not, you need to release it, because that could be a really, really bad day for you if you not only have to pay 3 times the amount of the deposit amount to the buyer, but you also have to reimburse them for all of their attorney's fees and court costs. Of course, we're going for all of it. I will keep you guys updated on this case. Let me know your thoughts in the comments though about this civil theft statute and whether you like or dislike the fact that you can recover 3 times the amounts of damages for violating this statute. Bye.